up to Capitol Hill. The Senate Commerce, Science, and Transportation Committee is holding a hearing on consumer data privacy that began just a moment ago.
Incorporate views from affected industry stakeholders and consumer advocates in an effort to promote privacy without stifling innovation. With that in mind, today's hearing will focus on the perspectives of privacy advocates and other experts. We will also continue to solicit input from additional stakeholders in the days ahead. GDPR and CCPA have undoubtedly spurred our conversation about a national privacy framework, and they give us useful examples as we contemplate federal legislation. Of course, congressional action on privacy is not entirely new. Over the last several decades, Congress has enacted legislation to protect children, health care, and financial information. Privacy debates have been ongoing in multiple sectors. Even the recently enacted FAA reauthorization includes provisions on privacy, specifically regarding the use of unmanned aircraft systems for commercial purposes. Federal agencies such as the Federal Trade Commission and the Department of Commerce have also performed long-standing roles regarding privacy and have been increasingly active recently in this area. At the same time, I am well aware that Congress has tried and failed over the last few decades to enact comprehensive privacy legislation. To be successful this time, we all must endeavor to keep open minds about the contours of a bipartisan bill. In the wake of Facebook's Cambridge Analytica scandal and other similar incidents, including a vulnerability in Google Plus accounts reported just this past week, it is increasingly clear that industry self-regulation in this area is not sufficient. A national standard for privacy rules of the road is needed to protect consumers. At the same time, we need to get this right. Passing onerous requirements that do not materially advance privacy would be a step backward. While it may be too early to determine the impact that GDPR and CCPA will have in the U.S., the most notable difference most consumers can see directly has been the increase in GDPR-inspired pop-up notices and cookie consent banners on their devices. As we continue to work toward possible legislation, I encourage my colleagues to challenge what industry told us at our first hearing, but also to examine both the potential benefits as well as the potential unintended consequences of the new rules put forth by the European Union and the state of California. So I want to say thank you to our panelists for being here today, and we'll look forward to hearing from you in just a minute. And I will turn to our ranking member, the senator from, Senator from Florida is here. Okay, Senator Nelson. Recognized for an opening statement.
Mr. Chairman, again, under your leadership in this committee, I will be returning to the Panhandle of Florida, and I want to say kudos to you because the assets that we have authorized in this committee overhead for NOAA, as well as the second airplane that flies at 40 to 45,000 feet, which has dramatically improved the National Hurricane Center's ability to project the path and the ferocity of a hurricane. And we know since in 2 hours, this is hitting landfall at ground zero about Panama City. That track has been solid there. So the local authorities have had ample warning, and the National Hurricane Center was right on the money. And a lot of that ability to forecast so accurately has come because this committee has authorized the assets. And I just want to say that this one is a big one. When you get above 100 miles an hour, the destructive force goes up exponentially. And because of the hot water of the Gulf, it has fueled it up to 140 miles an hour with wind gust up to 170. That will just about level most any structure unless it is made of concrete and steel. And that's the destructive force that we see approaching the Florida coast right now, which I will be going back as soon as we pass the water bill. I'll be headed back. So all of the agencies that this committee has jurisdiction, Department of Transportation, the Coast Guard, NOAA. I visited with those representatives in the Emergency Operations Center in Florida just the other day. So I just wanted to make that statement before I'm taken off.
Okay, thank you, Senator Nelson, and be assured that you and your constituents and our first responders will be in our prayers, and Godspeed and be safe as you travel down there. Thank you. Senator Markey, I think, has an opening statement.
Beautiful. Thank you, Mr. Chairman. Thank you for having this very important hearing, and again, all of our thoughts and prayers are with the Gulf Coast and this incredible storm which is about to hit Senator Nelson and all the people of Florida and any of the adjoining states that might be hit by this storm as well. I appreciate this opportunity to discuss a priority that I have personally worked on for years, which is protecting Americans' privacy. Data is the oil of the 21st century. It fuels all of the services, the apps, the websites that improve our quality of life and make America competitive in today's digital world. While the data-driven economy has undoubtedly revolutionized the way we communicate and conduct commerce, too often these changes have come with an unexpected cost to users. Many data-driven services use their customers' personal information as a commodity, collecting, using, sharing, and selling individuals' personal information without users' knowledge or permission. Consumers are frequently unaware of these practices and have no reasonable means to stop companies from mining and using their personal data for unwanted, intrusive purposes. Last month, this committee listened to the perspective of a few major industry players, and I was pleased to hear Apple, Google, Twitter, Amazon, Charter, and AT&T finally agreed that Congress must enact a comprehensive federal privacy law. But we shouldn't have any delusions about why those companies and their peers are all of a sudden advocating for a federal privacy law. It is clear that they are coming to the table because they now have to comply with a European privacy law, and even more motivating, they will soon have to comply with a California privacy law. Their hope is that Congress will pass a comprehensive federal privacy bill that preempts California and perhaps other more burdensome future state laws. But before we even begin to have a conversation about preemption, we need to agree on a strong set of standards that give Americans true privacy protections. Today's hearing is critical because we have the opportunity to hear from experts in consumer privacy about what that strong set of standards should look like. Our goal throughout the process must be to give Americans meaningful control over their personal information while maintaining a thriving, competitive data ecosystem in which innovators and entrepreneurs can continue to develop and flourish. That is what we are here today to discuss. I am supportive of strong federal privacy legislation. That bill should begin with the principle of knowledge, notice, and know. Consumers need knowledge that their data is being used or shared, notice when their data is compromised, and the ability to say no to entities that want their personal information. These are the principles of my Consent Act, which I have introduced. But there is nothing more than just merely the starting point on this discussion, because notice and choice are simply not enough. Transparency and opt-in consent are just the beginning. An American privacy law should also include limits on how companies can use consumers' information. The bill should prohibit companies from giving financial incentives to users in exchange for their personal information. Privacy must not become a luxury good that only the fortunate can afford. The bill should ban take-it-or-leave-it offerings in which a company requires a consumer to forfeit their privacy in order to use a product. Companies should not be able to coerce Americans into providing their personal information by threatening to deprive them of a service. This Privacy Bill of Rights should include the rights to access, correct, and delete your personal information that is held by a private company. The legislation should stop companies from collecting vast troves of users' personal information that have nothing to do with the company's offering. They should only collect that which is absolutely necessary to carry out the service. The bill should require companies to keep their customers' private information safe and secure, and we must make that daily data breaches a thing of the past. And the legislation should include special protections for children and teens who have a right to grow up and make mistakes without being monitored at every turn. Most notably, we need to extend special protections to 13, 14, and 15-year-olds who today enjoy no protections whatsoever. And finally, we must give the federal government and states strong enforcement powers. And the federal agency in charge of executing the law, whether it's the Federal Trade Commission or another existing agency or a new entity, must have robust rulemaking authority in order to ensure the rules keep pace with changing technologies. I'm confident that we can write that bill in a bipartisan way. We can give Americans their long overdue Privacy Bill of Rights and still allow our economy to thrive. And I am willing, and I think all members are willing, to work together to write this bill in a bipartisan way. I'm looking forward to receiving the guidance from the witnesses today. I thank you all for being here, and I yield back to you, Mr. Chairman.
Thank you, Senator Markey. Well, we're very pleased to have with us today a great panel. Dr. Andrea Jelinek, who is the chair of the European Data Protection Board, Mr. Alistair McTaggart, who is the board chair of Californians for Consumer Privacy, Ms. Laura Moy, who's the executive director and adjunct professor of law at Georgetown Law Center on Privacy and Technology, and Ms. Nuala O'Connor, who is president and CEO of the Center for Democracy and Technology. Thank you all for being here. We look forward to hearing from you. I would ask you, if you can, to confine your oral remarks to as close to 5 minutes as possible. Your entire statements will be made a part of the permanent record. But welcome, and we'll start on my left and your right with Dr. Jelinek, and welcome. Please proceed.
Thank you. Chairman Thune, Ranking Member Markey, and distinguished members of the committee. My name is Andrea Jelinek. I'm the head of the Austrian Data Protection Authority and the chair of the European Data Protection Board. Thank you for inviting me to address on the European Union's General Data Protection Regulation, or GDPR. As chair of the European Data Protection Board, which brings together the national supervisory authorities and the supervisor in charge of the European institutions, my task is to make sure we are all on the same page, because a key task of the board is to ensure the consistent application of the GDPR and to provide guidance to this end. My aim today is to shed some light on how the GDPR works and concepts behind it. I hope this testimony contributes to the extremely timely debate on the possible adoption of a comparable law in the US at federal level. The volume of digital information in the world doubles every 2 years. Artificial intelligence systems and data processing deeply modify our way of life and the governance of our societies. If we do not modify the rules of data processing game with legislative initiatives, it will turn into a losing game for the economy, society, and for each individual. Both in the US and the EU, people are more vocal about their right to data protection than ever before. The Facebook data breaches or misuse of data and other revelations have caught people's attention up to a point where it is necessary to re-establish trust. Trust has always been at the core of the economy, and this is even more true in today's digital society. More legislators and business leaders are stepping forward to say the time for overarching federal-level privacy legislation in the US has come. I think, for example, of Brendan Eich, CEO of Brave Software and former CEO of Mozilla, who wrote to this very committee making the case for GDPR-like standards. What shapes should such a law be? And this is, of course, up to the US policymakers to decide. The EU's GDPR and its functioning can serve maybe as an inspiration. Is the GDPR the perfect recipe? Actually, it is the result of an intensive consultation and collaboration process with all stakeholders and builds on rules that have been in place in Europe for more than 20 years. Under the GDPR, data can only be processed on the basis of core principles, including the requirement that data collection and processing shall be lawful, adequate, accurate, transparent, proportionate to the purpose for which it is undertaken and kept only for as long as necessary. Individuals must be informed about the main aspects of the processing of their data and are empowered to exercise rights on their data, such as to obtain access or demand erasure when the data is incorrect or processed unlawfully. Accountability is one of the GDPR's core principles, and the EU was inspired in this aspect by some of the principles stemming from your common law system. It relies heavily on business capacity to self-regulate. Organizations are responsible for complying with the GDPR and must be able to demonstrate their compliance. The market offer of new privacy or data security enhancing products is growing. In other words, investing in privacy pays off and creates new commercial opportunities. Data protection is a unique selling proposition. One of the greatest achievements of the GDPR is the one-stop-shop mechanism, which means a single lead supervisory authority is responsible for drafting a decision in a cross-border compliant case or data breach case. International or multinational companies operating in different countries have only one interlocutor to deal with. The lead supervisory authority is in the country in which the company has its main EU establishment. Any decisions taken by the lead supervisory authority are valid across the European Union. As European data protection authorities, we have rolled up our sleeves and actively engaged in a dialogue with stakeholders. This has included the adoption of 18 sets of detailed guidelines on many aspects of the GDPR, following broad public consultations to which many US companies contributed. This work will continue as new questions will keep emerging. How do we ensure that the GDPR is enforced? The 2% or 4% numbers that are often reported are maximum ceilings that will only apply to the most serious infringements. Fines are a last resort, just one of the tools which data protection authorities can use to enforce the GDPR, and only after a thorough investigation of the facts, and always on the basis of the specific circumstances of each case. Fines must be effective, proportionate, and dissuasive. As European data protection authorities, we stand ready to share our experience and expertise and further discuss these issues with all interested parties. Let me conclude with the words of one of the greatest US legal experts and one of the founders of modern privacy law, Louis Brandeis. The right to be left alone is the most comprehensive of rights and the right most valued by free people. 90 years have passed since Justice Brandeis so eloquently captured what privacy is about, but these words have never been truer than they are today in our digital world. Thanks for your attention, and I will be happy to answer your questions.
Thank you, Dr. Jelinek. Mr. McTaggart.
Chairman Thune, Ranking Member Markey, and members of the committee, thank you for this opportunity to testify today. It is an honor and a privilege. I come to you as the chairman of Californians for Consumer Privacy, the group that sponsored a ballot measure which resulted in the passage last June of the California Consumer Privacy Act, or CCPA. I also come to you as a father of 3 little children, concerned about the world they're growing up in, a world in which potentially every step and test they take and every decision they make will be tracked and sold to thousands of companies they've never heard of. And finally, I come to you as a business person. I want to touch on this because this is, after all, the Senate Commerce Committee, and you heard from representatives of giant corporations only 2 weeks ago that the sky will essentially fall if you leave CCPA intact. This law was rushed and badly drafted, they said, and it needs preemption right away. Well, I just want to say in public that I feel like I'm someone like, who I'm sure all of you, feels that commerce is one of the most potent forces for good in this country. I make my living in Northern California, where many of these tech giants are headquartered. And let me assure you that I have no wish to hurt either our state's or our country's economy. Neither I nor CCPA are anti-business, and the law was not rushed. On the contrary, we spent years talking to legal and technical experts, academics, businesses, privacy advocates, and its language reflects thousands of hours of careful drafting. Now, before I describe CCPA's three main elements, it's important just to remember that it only covers large business with over $25 million of annual revenue and data brokers buying and selling personal information. So the first component of CCPA is the right to know, which will allow Californians the right to find out what information corporations have collected about them. Next is the right to say no, which allows Californians to tell businesses to stop selling their personal information. Now, our rationale is simple. You're already paying these corporations either with your wallet or your eyeballs. Their business proposition is totally one-sided. Either have a cell phone, use the internet, and watch your information get sold, or go live in the Stone Age. We think that's not right. CCPA has a sensible solution. It allows companies to collect and use your information, including, importantly, to advertise to you. It just doesn't give them a license to resell that information for the rest of your life if you don't agree. The final major piece of CCPA involves data security. CCPA requires corporations to take basic measures to keep California's data safe. The world has changed post-Cambridge Analytica, which members of this committee know better than anyone, and data security is near and dear to voters' hearts. Companies need to do a better job taking care of our information. I entered this effort because I learned of a world where corporations are using your digital footprint to track you across the majority of the world's websites, whether you know it or not, creating a detailed profile of you and using it to take advantage of your life circumstances, whether they think you might be considering divorce, pre-diabetic, or a persuadable and gullible voter. Every click of your mouse and every term you search for helps create a digital file on you that dwarfs what any intelligence agency has ever known about its citizens. We understand that this committee is considering a national standard for data privacy, but we implore you not to weaken or undo the safeguards CCPA has so recently put in place, which now cover 40 million Americans. 1 in 8 Americans are now covered by this law. A law, I might add, that consistently polled at 80% and above. A law which 629,000 voters petitioned to put on the ballot. And a law which passed out of both houses of our state legislature unanimously. That's right, not a single Democrat or Republican voted against this law. And that's because privacy is not a partisan issue. All voters care deeply about it. So thank you for your time. We're committed to making sure that any national privacy legislation allows Americans the choice to take meaningful control over their information and their children's information.
Thank you, Mr. McTaggart. Ms. Moy.
Thank you. Good morning, Chairman Thune. Good morning, Senator Markey, members of the committee. I'm very grateful for the opportunity to present before this committee today. I wanted to start with a little context. I'm not here today because I'm worried about private information being made public. And although this is about the classic right to be left alone outlined by Brandeis and cited just a moment ago in this hearing, this is also about the need to grapple with the implications of unbridled data collection, storage, processing, and use. Things that give those who wield data more power to influence society than we could have imagined before the digital era. This is about confronting the ways in which the data-driven economy is contributing to extreme wealth disparity, extreme political polarization, extreme race and class-based tension, and extreme information manipulation. And this is not a time to be shy about data regulation. It's not a time for light touch regulation, which has already been tried and has led us to where we are today. Now is a time to intervene, and I thank you all for having this hearing. And here's where we should start. First, we should agree that there are things information simply should not be used for. Chief among these is discrimination. Information that Americans share online should not be used to selectively deny them access to or awareness of things like housing, education, finance, employment, and healthcare. Data should be used to increase opportunities, not to stifle them. Americans' information also should not be used to amplify hate speech or to enable data brokers to build ever more detailed profiles of us that they then turn around and sell to the highest bidder. It should not be used to target misinformation and disinformation that compromise our social fabric. Notice and choice are good when notice is understandable and the choice truly is a choice, but it's not enough. Second, we need robust enforcement. Congress must empower an expert agency to vigorously enforce the law, including with the ability to levy substantial fines against companies that violate their data obligations. In fact, staff and commissioners of the Federal Trade Commission have appeared before Congress directly requesting this authority. State attorneys general should also be empowered to enforce privacy. A single agency cannot hope to police the entire digital ecosystem. State attorneys general do indispensable work, both enforcing privacy laws and providing valuable guidance to companies trying to comply with the law. Congress should also consider creating a private right of action so that individual people can protect their own privacy when enforcement agencies do not. Third, we need a way to make sure the law will keep up with changing technology. We cannot know what the next privacy or data security threat will be, but what we do know, unfortunately, is that there will be one. That's why any new privacy law must include a mechanism for updating standards to respond to shifting threats. The best way to do this is to pass a federal law that creates a floor, not a ceiling, for privacy, so that states can continue to pass stronger laws on their own, as they are doing. Privacy and data security are extremely active issue areas for states, which are, after all, our laboratories of democracy. We should also have robust rulemaking authority for an expert agency. A regulatory agency can respond to rapidly changing technology more quickly than Congress. Fourth, we should not attempt to address complex challenges with a one-size-fits-all approach. There are different types of actors on the internet with different roles to play, different relationships with and commitments to users, different competition environments, and different abilities to solve problems. Industry has called for regulatory uniformity. That has a nice sound to it, but if we adopt a uniform approach to the entire internet, I fear that we may be left with the lowest common denominator, something that looks like transparency with enforcement that just prohibits deceptive practices. We already have that, and it has proven not enough. Americans are asking for more. Thank you, and I look forward to your questions.
Thank you, Ms. Moy. Ms. O'Connor.
Chairman Thune, Mr. Markey, and members of the committee. Thank you for the opportunity to testify today on behalf of the Center for Democracy and Technology about the need for federal privacy legislation. CDT is a nonpartisan, nonprofit 501c3 charitable organization founded in 1994, dedicated to advancing the rights of the individual in the digital world. We work on issues of individual privacy, freedom of expression, freedom from surveillance, and while also seeking to advance innovation and preserving a global open internet. My views today are informed not only by the research and advocacy of the lawyers, policy experts, and technologists at CDT, but by my own work on privacy and data issues across 3 decades. I have counseled internet startups, served as a privacy leader in 3 companies, and was honored to have served as the chief privacy officer for 2 federal government agencies under President George W. Bush. I am also a technology enthusiast and an optimist. I believe in the power of internet technology to improve our lives, as it has my own, as a consumer, as a member of my community, and as a busy working mother. Today, my message is simple. Privacy is about people. Privacy is about the digital and real-world data breadcrumbs we leave behind, the things we say and do, the choices we make, the way we spend our time, and how the data about all of these things can affect what we see and know and achieve in the future. Importantly, this is no longer only a question for tech sector companies. It is an issue for every company that uses data. You are online almost everywhere. You interact with and are observed by internet-enabled devices as you walk down the street, as you browse in the aisles of your grocery store. Information is being collected in the dashboard of your car, in your kids' schools, and in your kitchen. It is time to consider the impact of the ubiquitous data collection and to provide greater clarity and constraint on the collection and use of this information. Just as the United States has led the world on technology and data innovation, so must we now engage in the thought leadership on the governance of these innovations. It is time for baseline rules to provide certainty for all consumers and all companies, large and small, that recognize the rights of the individual in their own data and to rebalance the power differential in the data-driven economy. The Center for Democracy and Technology encourages you to pass baseline privacy legislation with at least the following elements. First, a comprehensive baseline federal privacy law should apply broadly to all personal data and all commercial entities whose data use is currently unregulated. Existing privacy protections should not be weakened, and important gaps in coverage should be filled. Second, the law should include individual rights like the ability to access, correct, delete, and move personal information. These values are already ensconced in both the California law and the GDPR. And certainly these provisions should be carefully drafted to ensure that companies can engage in their basic business practices and secure their own systems, and the regulatory structures and enforcement mechanisms must be tailored to our U.S. approach. However, the law must recognize an individual's ongoing interest in his or her own data and assert the right of the individual to understand the consequential decisions made about them. Third, Congress should prohibit the collection, use, and sharing of certain types of data when not necessary for the immediate provision of the service. One way to do this is to declare it presumptively unfair under Section 5 of the FTC Act for companies to use highly sensitive data, such as location information, microphone and camera information, children's information, health information, and biometrics for secondary purposes. Fourth, the FTC should be expressly empowered to investigate data abuses that result in discriminatory advertising and other practices. And finally, fifth, a federal privacy law should be clear on its face and provide specific guidance to companies and markets about legitimate data practices. The law should ensure that the Federal Trade Commission is empowered to enforce and provided with sufficient resources and original fining authority. Congress should explicitly empower the state attorneys general to enforce the law and any implementing rules. Achieving meaningful baseline privacy legislation will be challenging, but it is essential to continuing American leadership on innovation, creating confidence and certainty for individuals and for institutions, and restoring lost consumer trust. Your leadership is needed urgently. Thank you.
Thank you, Ms. O'Connor. We get right into the questions. Dr. Jelinek, as you know, Facebook is now being investigated by Ireland's Data Protection Authority in response to the recent cyber attack affecting 90 million users. I think this is an interesting case study that will help our members better understand how the GDPR is likely to be enforced. Could you explain exactly what your role will be as the head of GDPR enforcement?
I just want to explain, if you allow me, the functioning of the one-stop shop mechanism according to the GDPR. How does this work in practice? When a cross-border case is issued or a cross-border data breach is issued, like it is with the Facebook issue, we will look into the system who is going to be the lead supervisory authority. In this case, for sure, this is Ireland. Ireland, the Irish DPC, is going to put this in the internal system because we share a common IT system, and the Irish DPC is asking the other data protection authorities if they think that they are concerned. They are concerned if consumers or people in their countries are offended too. And in most of these cases, in this it will be that all the other data protection authorities are concerned authorities. That's the first step. The second step is the Irish DPC is investigating the case, is the interlocutor for Facebook, and then is making a draft decision on this data breach and shares these draft decisions with the other concerned authorities. If the other concerned authorities have any objections and the Irish DPC doesn't take this into account for their draft, it will trigger the board, and this issue is coming to the board who is working as an arbitration mechanism, and if they can't come to a common decision, then the board decides whether these objections the Irish TPC has to take into account or not with a 2/3 majority. And if the Irish TPC has to follow this decision of the board. That means the board is only then enabled to act when there are when the DPAs are not in line together, if they are not of the same opinion regarding the decision on a case. Okay. Then we're going to act.
To the best of your knowledge, how many GDPR investigations have been opened so far across the EU?
So far, at this moment, we have that the figures are from the 1st of October. We have 272 cases regarding identifying who is going to be the lead supervisory authority and who is going to be concerned supervisory authority. Just to give an example, most of the cases, the Irish or the Luxembourgish DPA are lead supervisory authority. Austrian supervisory authority is in 5 cases, lead supervisory authority. And there are 243 issues regarding mutual assistance, according to Article 61 of the GDPR, and there are already made 23 opinions regarding data protection impact assessment. So you see, beginning with the 25th of May, the board is already working on quite many cases.
It's a busy docket.
Yes. Yes.
So, from your perspective, what company practices have generated the most complaints or concerns from consumers?
I think the complaints that are most at the moment, there are complaints regarding consent.
Good. All right. Mr. McAllister, I'm sorry, Mr. McTaggart. Businesses have raised concerns that the CCPA will interfere with or even prohibit certain practices that consumers like. For example, some retailers have suggested that the law will make it impossible for them to have customer loyalty programs that reward their best customers. Do you think these are fair concerns?
Senator, this is one that we've heard before, and frankly, it just mystifies us. We can't see anything in the law that prohibits loyalty cards. And in fact, we think that there's nothing in the law that prohibits companies that have a first-party relationship with consumers for using their data if the consumer consents. So we can't see that. I'm happy to respond to any of your staff members in the QFRs after.
Okay. So if that's the case, I mean, the question of how you would address them in federal legislation and maintain the same level of consumer privacy protection, it seems like that would be an area of discussion. Obviously, you say that it's not an issue, but that's an argument that's being made by those that are in that industry.
I think one of the concerns, and Senator Markey brought it up, is with respect to whether you're able to offer different pricing mechanisms to consumers who want to have privacy, put a premium on privacy or not. It's a thorny issue. Where we ended up saying is that the companies were able to, but we limited it, and we said that the choice can't be coercive. I mean, the company's increased price for privacy can't be coercive, can't be usurious, can't be unjust or unreasonable. I think we always tried to strike a balance, and that struck us as striking a balance to allow companies to have a different arrangement with consumers who want privacy. And I will say this is an area of contention because some people feel very strongly that there should be absolutely no differentiation. Where we feel is that if we let the market decide along, but we have some certain basic limitations, that is a way of allowing the company's flexibility, because you don't want to be in a situation where you're saying that the company has to offer a product for free.
Are there any provisions of the CCPA that you think could benefit from further revision or clarification? I know there's some discussion out there about doing that before it becomes enacted.
Sure, Senator. We just spent a couple of years doing this, and the opponents will say it was quickly done and badly drafted, but essentially the rush part was the actual passing of the legislation in the final couple of weeks, and that was rushed, but essentially the language was taken from the initiative, so we feel it works very well as is. We gave up some things that was just part of the compromise. There was a whistleblower provision in there, and I do feel like that would have been nice to have, because sometimes it's so hard understand what's going on in these very complicated companies, that I think that would have been a useful thing to have. But importantly, one of the things that we did was we gave the California Attorney General the right to issue regulations. And I think that's so important going forward if you do a federal bill to give the rulemaking authority to the enforcing authority, because you don't want a bill that's going to be stuck in time. And so we feel that because we gave the AG the right to issue regulations, that'll allow the bill to be flexible with time.
Thank you. Senator Markey.
Thank you, Mr. Chairman. Ms. Moy, should companies be able to tell consumers that if they don't agree to share non-essential data, they cannot receive the service or the product?
No, they shouldn't be able to tell consumers that. And I think that really gets back to the idea, to the question of what constitutes choice in a notice or choice. Even if we have notice and choice, which is, as I've said before, I think not enough. I think we still need use restrictions as well. But a choice has to be a real choice. I think that this is something that the GDPR does well. It says that consent must be freely given. When a company says, accept our practices with your data or don't use the service, that's not a free choice.
Okay, great. Now, should companies be allowed to offer financial incentives in exchange for Americans' personal information?
I support skepticism toward financial incentives for certain data practices, because I do recognize that while there may be a value that consumers enjoy in exchange for their data, as Mr. McTaggart just mentioned, oftentimes the financial incentives that companies offer or the financial penalties that they levy against consumers who decline to give consents are not truly commensurate with the value of the information that, as the company realizes it, they are in fact coercive.
Okay.
So,
should companies only be permitted to collect the information that is essential to providing the service or product in question? Should a flashlight app be able to collect information about my interest and location?
Yes, right. Yeah, no, I agree with you. Information collected by a site or service should only be that information that is necessary to actually provide the site or service. That seems like a bare minimum.
Okay, so Ms. Moy, AT&T recently announced that it will stop sharing users' location information with data brokers. Facebook has stated that it will stop allowing advertisers to use information about users' race and religion to exclude some users from seeing particular advertisements. Do you agree that such practices should be banned? Not just left to voluntary compliance by companies? Should a federal privacy bill establish limits on how companies can use Americans' information, not rely upon voluntary actions taken by individual companies?
A federal privacy bill absolutely should establish limits. The case that you mentioned with major phone carriers providing location information about their consumers to third parties who had paid for it, it's completely egregious use of consumer information.
Right. Should consumers have the right to access, correct, and delete their personal information in manners inconsistent with existing laws?
Yes.
Should Congress establish enhanced data security standards to protect consumers' private information?
Absolutely. Sorely needed.
Let me move on to children's privacy. I would like to go to you, Mr. McTaggart. It's a subject that Senator Blumenthal and I have been working on. In 2018, we're seeing issue after issue where children's privacy is being compromised. I'm the author of the 1998 Children's Online Privacy Protection Act, COPPA, which is a law which I wrote back in 1998 with Congressman Billy Tozan. Mr. McTaggart, the California law requires both online and offline companies, regardless of whether these businesses target children, to obtain opt-in consent from parents of children under 13 before collecting or selling their personal data. In addition, companies will be required to obtain affirmative consent from consumers between the ages of 13 and 16 in order to sell their data. Mr. McTaggart, do you believe a federal law should also grant special protections for 13, 14, 15-year-olds?
Yes, Senator.
Do you agree with that, Ms. Moy?
Yes.
In terms of the eraser button, which at least should be usable by parents with children 15 and under. Do you agree that there should be an eraser button, which is part of the law, so that if a 12, 13, 14, 15-year-old has done something online which is inappropriate, that doesn't haunt them for the rest of their life, that they should be able to just demand through the parent that that information is erased. Do you agree with that, Mr. McTaggart?
Yes, Senator, and all I would say is that the First Amendment does have implications here, and so when we look into it, it gets a little difficult, but yes, I do.
Yeah. Ms. Moy.
Yes, as the mother of a 5-year-old, I am terrified about the things that I know he will surely post online when he is 13. I do support a right to deletion of some sort for teenagers.
Okay, and can we square that with the First Amendment, Ms. Moy?
I think that there are ways to do it. Yes.
Okay, great. Do you agree with that, Mr. McTaggart?
Absolutely, yes. I just think it's thornier than it looks.
Okay, great. Thank you. Thank you, Mr. Chairman.
Thank you, Senator Markey. Senator Wicker.
Dr. Jelinek, under EU policy, your board could have chosen the regulation route or the directive route. A regulation places a binding legal force throughout the continent. A directive would simply have had each country try to implement according to their own national laws. GDPR went the regulation route. The goal was and is to have one set of privacy rules that are interpreted in a uniform way throughout the continent. Why did you do that, and why was it important to have one data privacy policy instead of each member country having their own?
Thanks, Senator, for this question. The EU already had a data protection directive from 1995 on. And this data protection directive had to be set into the national laws of the 28 member states. So we had diversified laws, even if they had the same fundament. And during the last 20 years, the EU considered that it would be much more better to have one applicable law according for the whole continent, for the whole EU. And so it started in 2012 to negotiate the regulation, and the regulation was finalized in 2016 and entered into force and entered into application on the 25th of May 2018 to have one continent, one law.
Okay, and with regard to how it's being implemented and how people have reacted to this. There have been reports that upon implementation, several companies shut down their operations, blocked access to European users, or required European consumers to pay for access to online content. Could you comment about that? Has that been overblown, or am I accurate in what I've stated there? And why would the companies have done so?
I can't contribute to why the companies have done that, but as far as I can tell you, is most of the companies on either side of the ocean, US companies and European companies, were preparing quite well for the entering into application of the GDPR. They had more than 2 years' time to prepare. The 25th of May was not the end of preparation. It was just the beginning of the common journey in the new field of data protection, because data protection was not that new, because as I just mentioned, we had already a directive from 1995 on, and the GDPR was no revolution, but just an evolution of the law that already existed.
Okay, let me ask Ms. O'Connor about this preemption idea. Ms. Moy suggested in her testimony that what we do here in Congress should establish a floor, not a ceiling. It seems to me that you feel the other way. So why should there be one? Is it your position that there should be one privacy standard for the entire country coming out of this Congress? And if so, why?
I think it's better for American consumers to know what the rules are, no matter what company they're dealing with in whatever country or state that companies based in, but I am not seeking a lower standard than we have. We would not seek weakening of existing laws. We would very much applaud the effort that was made in California and want to see strong protections. So, while I think it's too early to talk about preemption, I think one of your colleagues has suggested that the price of preemption would be very, very high.
Okay, why would a patchwork negatively affect consumers, though? That you alluded to that just now in your verbal answer, and it's in your written testimony too. How would it affect consumers adversely to deal with a patchwork from state to state?
I think there would be uncertainty and a lack of clarity about what the rules and guidelines are for each individual dealing with companies all over the country. And also, it does not get us standing in the global dialogue on data protection. Europe is leading the way, and other countries and regions are following a European model. I'd like to see the United States offer an alternative that has strong baseline protections, and I would agree with Ms. Moy that it's a floor, not a ceiling, but that would provide some leadership from Congress for all of the states, attorneys general, and the FTC to enforce.
But maybe you could supply on the record an example or two of how a consumer could be disadvantaged by a patchwork. Mm-hmm. We'll just ask you to do that on the record. Will you do that?
I will do.
Thank you, Mr. Chairman.
Thank you, Senator Wicker. Senator Blumenthal.
Thanks, Mr. Chairman, and I want to thank you and our ranking member for pursuing this issue on a very bipartisan basis. I'm working with a number of my colleagues from both sides of the aisle on a bill that I hope will have strong bipartisan backing that, in fact, sets a floor, not a ceiling. We can no longer rely on notice and choice, on voluntary standards, on transparency and consent. There needs to be privacy by design. Call it a privacy bill of rights, call it a mandatory standard or a floor. That kind of bill of rights should incorporate essential principles that both the European law and the California law embody. I want to thank all of you for being here today, but particularly Mr. McTaggart for championing this cause against great odds and strong adversaries in California, as you did, and your continued dedication to this cause. I want to ask all of you the same question I put to the executives of major companies that came before us. Is there anybody here who believes that American citizens deserve less privacy protection than European citizens? Your answer is the same. Everybody agrees that Americans should have that same privacy. Is there anybody here who believes that the people of Connecticut or anywhere else in the nation should have less privacy protection than the people of California? No one. So we all agree on that basic principle. And I think this cause is one whose time has come. And I want to mention the elephant in the room. We learned last Monday of yet another breach of the public's trust by a big tech firm. Last May, Google discovered a vulnerability in its social network product, Google+, that left private data exposed to outside developers, more than 400 of them. According to the Wall Street Journal, Google decided that it would not disclose the issue. In fact, it hid the problem to avoid bad press. Thanks to the Wall Street Journal for disclosing a memo, I believe it was the Wall Street Journal, from one policy staff member who argued that disclosure would result in Google, quote, coming into the spotlight alongside or even instead of Facebook, despite having stayed under the radar throughout the Cambridge Analytica scandal, end quote. The fact is that consumers have no meaningful federal protection for consumer data. All we have is congressional oversight right now and whistleblowers who come forth and press reports. until there is an effective enforcer at the federal or state level with federal standards backed by strong resources and authorities, consumers will continue to be at risk. I will be calling later today in a letter to the FTC for an investigation of Google in connection with this incident. I hope to be joined by a number of my colleagues. I hope that European authorities will investigate Ms. Jelinek. Do you have an interest as an investigator in this violation of basic norms by Google, in the failure to disclose for months and months? Put aside the breach of standards and vulnerability that was discovered, the failure to disclose purposefully because of the potential embarrassment.
I just want to answer just brief. The Irish DPC is already investigating the case, and the Hamburgian Data Protection Authority too, because not each and every data protection authority is able to investigate because the breach was before the 25th of May. And this shows as a good example how easy it could be for the consumers and for the companies if they already had if the breach would have been after the 25th of May and Google would have had a main establishment in Europe, then they just had to face one investigator, one investigation. So they will have to face more than one from the European authorities.
My time has expired, but I'm really delighted to hear that there will be an investigation. I hope it will be a combined and coordinated one with our Federal Trade Commission or other authorities in this country, because I think this kind of deliberate concealment is absolutely intolerable. And thank you, Mr. Chairman.
Thank you, Senator Blumenthal. Senator Moran.
Mr. Chairman, thank you. Thank you to you and Senator Markey, and thank you for our witnesses for your presence here today. I chaired the subcommittee of this full committee on consumer protection and data security. Our subcommittee, as well as this full committee, remains totally committed to a better system than what we have today. Let me begin with what I hope is a yes or no answer, what I think can be a yes or no answer to Dr. Jelinek and Mr. McTaggart. I mentioned this in our hearing that we had on the 26th, the privacy of consumer data, that I support privacy rules that afford consumers the same protections no matter where they are in the internet ecosystem. And it appears to me that both GDPR and CCPA take a similar approach. Rather than regulating the type of business handling the data, would you agree that regulating and enforcing privacy rules based on the sensitivity of the data collected, used, and transferred or stored is the preferred approach and in the best interest of consumers in terms of certainty and transparency? I think that can be a yes or no answer. Dr. Jelinek?
I think it's very important that the consumer know what which data are collected, which are they and where are they stored, and how long they are stored. And I think it's really important, yes, to know for the consumers.
Senator, we treat all personal information the same, so yes.
That's the point, Dr. Jelinek, that I'm trying to get to. It doesn't matter what ecosystem in the internet world you're in. It doesn't matter who the provider is. We want people to be treated the same.
Yes, the people have to be treated the same.
Thank you very much. Mr. McTaggart, the CCPA defines personal information to mean information that identifies, relates to, describes, is capable of being associated with, or could reasonably be linked directly or indirectly to a consumer or household. Are you concerned that that broad definition of personal information sweeps in information that isn't sensitive? What does it mean that information can be linked indirectly with a consumer or household? That sounds somewhat removed from information that can identify an individual.
Senator, we took that definition from pre-existing California law. I think one of the things to think about is that the game now is to get control of, is to find out what your device is. And so we're trying to make sure that your device is captured in there, because increasingly people, Google was in here 2 weeks ago and they said they didn't sell personal information, and then when pressed they said, well, personal information is your name or your email address. But the reality is it's your device. That's what if I know everything about your device, I know everything about you. And so we think our definition is appropriate because it's linking back to an individual, and it's being able to track them across whatever they do.
If I understand correctly, what I described as broad is intentional to alleviate others having a narrow definition.
Right, we're trying to avoid game playing, and again, go back to the fact that we gave the AG, regulatory authority to issue regulations around this to clarify things if it does turn out to be a problem. But also, technology is going to move, and you want to be able to keep it pace with the times.
Thank you very much, Dr. Janelic. Mr. McTaggart's testimony described the differences between CCPA and GDPR, and one of the specific points he made was that GDPR's requirements of obtaining consumer data. Obtaining consumer approval before collecting and processing their data would specifically harm new entrants to the marketplace, since consumers are far less likely to provide upfront consent to newer, lesser-known companies. Do you think that Mr. McTaggart's criticism of GDPR is valid?
I think it wasn't a criticism in that case. It's a different approach, because I think it's important that you know if somebody is collecting your data and that you can give the consent for the processing.
This may be a follow-up to you, or maybe you, Mr. McTaggart. It's obvious, at least to me, that larger companies like those we had in front of us recently, they have large legal departments, compliance officers that allow them to better react or respond to the regulations proposed by either California or the European community. But smaller and newer companies are not likely to have those resources. Do you have any concerns regarding this impact that the enforcement actions related to GDPR compliance could have on small entrepreneurial businesses? Either one of you.
As the enforcement action, as the fines are only the last step, I think it's no problem because we can make warnings and reprimands at the first. Two, not only fines. That's the first thing, and the second thing is the second issue is the fines have to be proportionate, always proportionate. It's always also proportionate to the if it's a big or a small company and how they tried to comply before. It's not that it's possible to fine a small company as a big company, because a small company has a different revenue and has a different approach.
So what you're suggesting is that the ability to warn is compared to enforce, or if enforcement, the smaller the fine, that offsets the small nature of a business.
No, it doesn't. It doesn't be dependent of the small or big business. It depends of the nature of the business, because also a small business, if they are doing in health apps, they have 2 people, but they're doing in health apps. This can be a business who is doing and just dealing with data. And so it's not a question of if a business is big or small, if there can be imposed fines. It's a question of the nature of the business and of the nature of the infringements. Article 83 of the GDPR shows us 11 grounds how to impose the fines.
Thank you very much. Well, I've had a chance only to visit with 2 of you. I appreciate all of you being here.
Thank you, Senator Moran. Senator Hassan.
Thank you, Mr. Chair. And again, I want to thank you and Senator Markey for holding this hearing, and to all of the witnesses, thank you for being here today. Dr. Jelinek, I wanted to start with a question to you. Under the GDPR, companies must notify consumers of a data breach on an occurrence standard. Several of the privacy principles that have been released by the industry call for a harm standard, meaning that consumers would only be notified if a breach results in so-called measurable harm. And as Senator Blumenthal just referred to earlier this week, it was reported that Google experienced a multi-year data leak that affected over approximately 500,000 accounts. However, the information that was leaked did not reach any legal threshold that would require public disclosure of the leak. This incident further highlights the need for a closer look at how we might structure data breach notification in federal legislation, as it's really concerning to me that an incident affecting this many people didn't have to be disclosed publicly. With this in mind, could you discuss why the crafters of the GDPR chose an occurrence standard over a harm standard?
As I was not negotiating the GDPR, I can't tell you the reasons behind.
Yes.
But as far as we know, as regulators, the reason behind is the timeline. 72 hours is quite enough to make a first notice.
Yeah.
That's the first thing, because you have to look into the breach more thoroughly. It's clear that it can't happen within the first 72 hours. That's the first thing. And the second thing, the measurable harm for the people, I think, first of all, there are guidelines issued by the Working Party 29, endorsed by the EDPB at its first session, what is a measurable harm.
Yeah.
But as far as I see, and I'm sure all of you here in this room know what is a measurable harm.
Right.
Because if you're already thinking as company, how could this affect my consumers, you should notice them. And as far as I know, there was no problem for all the big tech companies to make notice to their consumers, to reach out to them.
Well, thank you. I appreciate that. I wanted to follow up with another question to you. We've talked a lot about how to prevent data breaches, but I don't think there's been enough discussion about how to limit the damage when a data breach actually occurs. One of the best ways to do this is to limit what types of data a company can hold on to for an extended period of time. For example, when I was governor in New Hampshire, I worked with both law enforcement and privacy advocates in my state on automatic license plate reading technology. Under the compromise we worked out, law enforcement has access to license plate data for a brief period of time, but then the data is erased if the vehicle isn't linked to a warrant or to an alert. To me, that seems like the right kind of balance between utility and privacy, although I will bet right now that my law enforcement folks would argue that we still haven't gotten that balance exactly right. What are the reasons a company would need to store data for longer? How do we balance holding data for the possibility of using it for purposes such as innovation with the possibility that holding on to data could mean that more consumer information would unnecessarily be released in the event of a breach? And I'll start with you, Dr. Jelinek, and then I'll ask the others to weigh in.
Regarding to the GDPR,
yeah.
If you store the data longer than you need it, you don't act in accordance with the law. That's
okay.
The first thing. And the second thing is, if you just have to hold the data for the issue though you are processing it.
Yeah.
And so the best limitation is if you don't hold it longer, so you won't risk a breach.
Yeah, understood. Anybody else like to comment on that? Mr. McTaggart or Ms. Moy? Yeah.
So I think, the point that you raise about data retention is a really interesting one, because the financial incentives are set up to encourage companies, in fact, to keep information for as long as they can, because, something that may not be useful today to extract information that could be useful for marketing purposes or for some other purpose might be useful in the future using the analysis technology that is developed in the future. So without both principles that require minimization of data and require limits to retention, as well as strong enforcement authority that would cause entities holding data to fear the repercussions of keeping information for too long, then that practice is likely to continue.
Well, thank you, and thank you, Mr. Chair.
Thank you, Senator Hassan. Senator Cortez Masto.
Thank you. And I also echo my colleagues. Thank you for having this hearing, Mr. Chair, and thank you for all of you being here today. I want to follow up on a question I actually asked the last panel, and you touched on it, Mr. McTaggart. And this is the idea that the tough question for Congress right now as we draft this privacy law is how we define sensitive information versus non-sensitive information. And I asked that question to the panelists, and you're absolutely right. They all kind of defined it a little bit differently. So it would help me if you could help give us a better understanding. In California law, I understand, eliminates the idea that sensitive versus non-sensitive distinction for the law's notice and opt-out requirements. Can you talk a little bit more about that, how you have done that?
Essentially, we just treat all personal information the same, and we give consumers the control over it by saying, you can choose who to do business with. What we found in our research, what bothers consumers is the sense that that's being transferred and sold to companies they've never chosen to do business with and that they have no knowledge of. And I think one of the things that Ms. Moy just touched on is information changes over time. So what wasn't sensitive now becomes sensitive because now you can do something with it. So what we basically say is, look, all information you should have control over. But we kind of respect that consumers understand that they're going to do business with a company, and so that first-party relationship is where we end up sort of drawing that line.
So would this also then address the concerns that I heard earlier, I think it was the chairman, about the customer loyalty programs? So this would be information then that the customer would decide that they want to share with those programs, and it wouldn't get caught up in whether it is personal information or non-personal information, sensitive or non-sensitive. It is a broader category.
Right, because the customer is deciding to do that.
Right, yeah. And it's up to the customer to make that determination. Got it. The other area that I'm interested in hearing a discussion on is the idea about data minimization. And I think it goes back to what I believe it was Senator Markey talking about, the flashlight app example. I understand one component of the GDPR is a concept called data minimization, and it's just what I believe Ms. Moy talked about, is that the principle states that data processing should only use as much data as is required to successfully accomplish a given task, and data collected for one purpose cannot be repurposed without further consent. It's my understanding. So I'm going to ask both Mr. McTaggart, but Dr. Hellenic, if you would talk a little bit about how that is addressed in the GDPR, the data minimization, the implementation of it. I'm interested, and how are smaller entities dealing with this provision?
Senator, I went into Supercuts last week to get ready for this, and since the time I went to this haircut from the last time, Supercuts now has a little kiosk, and they wanted my email address and my cell phone number to check in, and I was the only person in line, and you know, the data collection has just gotten out of control, and I think that's one of the reasons why we're here, because Americans have no certainty about where it's going, who's ending up with it, who's buying it. We do know it's getting stolen with regularity, and I think that CCPA provides a meaningful approach to that.
Thank you.
The GDPR addresses it like that you just have to process the data who are needed for the treaty you're working on. If you have, if you just need the data for, if you just need the minimum data, and if you just process the minimum data, which is provided in the GDPR, because that's one of the core principles, that you have to minimize the data. You don't have to have the data of some outer thing if you just have a treaty regarding you buy a car. So you just have to provide the data regarding this treaty and not anymore.
And so then you rely on those companies to self-regulate, and if they are somehow caught doing more, then that's where the enforcement comes in, and robust enforcement, like I heard, I think it was Ms. Moy talk about the need for?
This robust enforcement can take place, yes.
Okay. And so I know I've only got a few minutes left. I'm also interested in the idea of this enforcement, because I do believe there is the opportunity to self-regulate, and then how we look at what the enforcement is necessary. And I agree. I don't think it should be one size fits all. I think in this committee you have former attorneys general. I think there is a dual role here where we can work together at the federal level with the FTC along with the AGs. And the reason why I say that is because I know there are cases that the FTC may take that and may not take, that are necessary for individual states to address, that won't be addressed if we just leave it to the federal authorities. I also know there's an opportunity for both to work together. The one thing I would caution, however, is not all AGs are the same and their authorities are not the same. So the Attorney General in California has regulatory authority, making authority. AG in Nevada does not. So as we go down this path, we really have to understand that enforcement piece of it, but I agree. And I think there is a role for us to work together. So my time is up, but I would love, and I've got further questions on this piece of enforcement and how you think there is this dual role and still not over enforcement and over regulation of the company, so they can still be free to innovate and be successful in their businesses as well. So thank you. Thank you. I know my time is up.
Thank you, Senator Cortez Masto. Senator Young.
Well, thank you, Chairman. I want to thank our panelists for being here today. One of the areas I'd like to touch on in this important discussion about privacy is the insufficient, at least as compared to previous generations, number of startup companies that we see being created. Much has been written about this, but and this exists within the internet ecosystem and certainly outside of it as well. But regulation, particularly those regulations that are somewhat hard to understand and may be difficult to comply with, tend to be favored by incumbent firms in any industry. Just economic incentives sort of dictate that. So that raises some concerns I have with respect to GDPR and the approach that's taken there, and potentially by California. I'll just start with Ms. Yelnick. Perhaps to a greater degree than under the EU's regulatory model, the United States, we tend to adopt a somewhat more flexible regulatory approach, by my observation, by reputation certainly, than the EU does. There are advantages and disadvantages to that approach. But do you have concerns that startups in particular might suffer under the approach the GDPR has taken? And if so, what steps are you taking or will you take moving forward if you discover that startups are being stifled by the approach the GDPR has taken?
Thank you, Senator, for this question. I think just for startups and SMEs, the GDPR is a chance, because if they are just at the beginning of their business, they can already take into account the rules and adapt from the beginning on through privacy by design or privacy by default. And I think it is just really a USP for the small SMEs and startups if they just take into account from the beginning on the rules of the GDPR. And if they start when inventing a new processing or things like that, they can rely on a robust model like the GDPR when they want to do business in Europe too, and they can do it through the same rules in all Europe, and they don't have to be compliant to 28 different laws just to be compliant to one, to the GDPR. And that's quite easier also for small businesses.
Isn't moving forward there a real advantage to incumbency here, though? Because you know, if your business model is to maximize profits through the sale of advertisement, you already have tens of millions of users out there and are enjoying all the revenue advantages of having those existing users and the network effects associated with those users. And then you've established a new regulatory regime like GDPR or perhaps the California model. Aren't you disadvantaging new entrants into the space? I'm not saying that your approach is the incorrect approach, but I just would like to know how you've tried to navigate this.
I think I made this clear. I think it's really an advantage for new businesses to have a robust set of rules for all Europe if they want to make business there. Okay. Mr.
McTaggart?
You know, Senator, I think one of the reasons we decided to set the threshold at a high revenue, 25 million, is by definition you exclude startups. So they're not covered because, and nor the mom and pops, which is the backbone of the economy. And I feel like if you're showing up, you're going to give the right to collect your information to the Googles and the Amazons and the Facebooks because you already know them. The new company, it's going to be harder to compete. So one of the reasons we wanted to say, we put the line on the outside saying, all companies have to give the consumer the right not to sell their data. But on the collection side, we were sort of silent because we understand that that's one of the, how does the next Google show up if no one's going to give their information to it in the first place?
Sure. Ms. Moy?
Sure. Just 2 quick points. So one is that I think that this is one reason that rulemaking is really important, to provide clarity in advance, as well as state AGs, which do a lot of important guidance. Another really important thing to talk about is data portability, which helps new entrants to the marketplace. Sorry.
Good point.
I think it's incredibly important to be protective of the small business, but I would like to remind the committee that Cambridge Analytica was a small business. The damage that can be done by small entities holding vast amounts of data is certainly equal to large entities holding vast amounts of data. I would not exempt small entities from a baseline comprehensive privacy law, but I would certainly be concerned about making sure the rules are clear and simple and provide direct guidance for all new entrants to the market. I'm very concerned about the new entrants to the market, but I don't think the laws should exempt them.
Right. Thank you.
Thank you, Senator Young. Senator Udall.
Thank you, Chairman Thune. And since this committee held a hearing to protect consumer data 2 weeks ago, consumers have already been subjected to 2 extraordinary data breaches. And I believe Chairman Thune mentioned one of them, the Facebook. Hackers access 50 million Facebook users, although Facebook still does not know who the hackers are and which accounts were hacked. And Google just disclosed this week a security flaw that it discovered in March that affected hundreds of thousands of people using its Google Plus social network. It seems like hardly a week goes by that there aren't new examples of how tech companies are just not doing enough to protect consumer privacy. In our last hearing, I raised the issue of this in terms of children. Parents often trust these platforms with their children's information. As part of this privacy discussion, we must prioritize protecting children in this increasingly online world. And this question is to Ms. Moy and Ms. O'Connor. The nature of the internet has evolved from a keyboard to mobile devices that fit in our pocket to the current day iteration of voice interface. Is COPPA an example of the regulation that has adapted with the rapid evolution of technology, and how has this law succeeded in keeping up with these changes, and how has it failed?
Thank you. So the Children's Online Privacy Protection Act, I do think that one thing that's really great about that act is that it gave rulemaking authority to the Federal Trade Commission. The Federal Trade Commission did expand the definition of personal information in its implementing rule in 2012 in an attempt to keep up with rapidly advancing technology. I agree that additional protections may be needed for children in the modern era. That said, I do think that COPPA has proven itself to be a pretty flexible law.
Yeah. Ms. O'Connor.
Thank you, Senator. You know, as a mother and a soon-to-be stepmother of 6 children, ranging from 9 to 19, I feel strongly about the step-up nature of the use of the internet from the youngest to the oldest teenager and so on. COPPA certainly has its strengths, and it's been effective in its enforcement by the Federal Trade Commission, but as you know, it stops at 13, and there's a big gap between the young teen and the adult, and we need to explore what that world looks like for those in transition from teenage to adulthood. We also, as you correctly point out, are moving from a world where the internet was something you sat down to do at your computer, to carry around to your phone, to embedded in the walls of your house and your school and your car, and we are particularly concerned at the Center for Democracy and Technology about the use and collection of data in schools by for-profit companies and by other entities, and what that kind of data determinism looks like as kids apply to college and beyond.
Thank you very much. This question's to the entire panel. A recent New York Times analysis found that both the Apple App Store and the Google Play Store have apps in their respective children's or family sections that potentially violate COPPA. What specific roles should platform owners play to ensure compliance on their platforms?
Senator, in the hearing 2 weeks ago, the representative from Google said that they relied on the app developers to tell them whether or not it was a child-directed app, and they relied on the app developers to self-certify. And this is, I think, where a good example of the fact you need really robust enforcement. I mean, you know, it's like waiting for the cops, you know, to call the cops and tell them you've been speeding. I mean, it's just, it doesn't work, sir.
What would you do in Europe with this kind of situation?
In Europe, with this kind of situation, it depends. The controller can't rely on the app developer, because the controller is responsible for what he's doing and for what he's providing. And if there are problems regarding children, and there are complaints, or also if there are no complaints, because we can have investigations ex officio, we're going to investigate those cases.
I do think that, so there are a couple things that have proven problematic. So one is that there are incentives set up essentially for those that have app stores to essentially just have no knowledge of whether or not apps on their platform are directed to children. That is a gap that should be fixed. And I've lost my second point.
Well, we certainly think that the immediate company, the app developer or owner, is the ultimate responsibility. We certainly would look at what kind of compliance mechanisms exist for the larger platforms to take action against those companies that they become aware of that are not complying.
Thank you, and my time's expired. And thank you, Mr. Chairman, for really focusing in on this and having a number of hearings.
Appreciate that. Thank you, Senator Udall. Senator Schatz.
Thank you, Mr. Chairman. Thank you all for a great panel. I really appreciate the plain-spokenness of your expertise. It's really useful for the general public, because this really does matter to a lot of people. As I mentioned in the previous hearing, you know, the reason we're having a more robust, more serious conversation about a federal privacy law is that there is this California privacy law, and it is forcing folks to the table that have been so far hesitant to have this conversation about federal law. My analysis, and it's informed by what I'm starting to hear, is that some of the tech companies are really serious and want to do this, regardless of whether or not the California law gets amended. Others are trying to figure out where and how they can do the minimum, which is to say, if they can get the California law weakened, then they're going to back off of their support for a federal privacy statute. And so I want us to all not pretend not to know that that's happening. That is exactly what's happening. That is the context in which this negotiation is occurring. And so let me just go down the line. And the first question, in my view, is the FTC's rulemaking authority. You can't really have a law in this space without the FTC's ability to be the expert agency and to enforce. And so do you think a federal privacy law ought to have FTC rulemaking authority, starting with Dr. Jelinek?
I have to tell you that's a decision of the U.S. lawmakers.
Well, that is fair enough. Thank you. That was actually my thought, but I wanted to be inclusive because I didn't want to skip it. Thank you.
You could run for office in this country.
Yes, absolutely essential.
Yes, and direct fining authority, not reliant on consent decrees.
Can you flesh that out a little bit, Ms. O'Connor?
Sure. And I've actually worked once at a company that was under investigation by the FTC, so I'm well aware of the zealousness with which they pursue their action. And they're a terrific agency with really talented staff. Not enough of them, only 60 staffers for the entire United States working on data privacy in particular, and reliant on the FTC's Section 5 unfair and deceptive acts and practices provisions. That's not a direct enough instruction to the agency. That's why the body needs this law to say this is what's in and this is what's out for companies. This is what's allowed and what's not. But they can't. They have to wait until they find a malicious or an untrue statement in a privacy policy, then take action, then have a consent order, and then find a violation of that. That's a lot of time and water under the bridge before we can get to solve the harms.
Because as you're sort of balancing what your general counsel says versus what your coders say, versus what your shareholders want, you just say, why don't we just run this and figure out how much trouble we're going to get in 3 years once we're 10 times as large, right?
And having worked in some of these companies, the engineers and the computer scientists tell me, just tell me what the rule is. I want one clear rule. I want to understand what I'm expected to do, and I will code to that. I will fix that. I will make that happen. But waiting until we test what the boundaries of harms are is not working for consumers in this country today.
Ms. Moy, Mr. McTaggart, anything to add to that?
Yeah, I'll just add that I agree completely, of course, that finding authority is needed for the FTC, and it must be substantial penalties, right? I mean, under the GDPR, I think that the penalty can be up to 4% of a corporation's annual revenue. The penalty against Google in 2012 for violating its consent decree was only $22.5 million, and that was just a few hours of revenue for that company. So that not only must there be penalties or fining authority for the FTC, but also those fines must be substantial, such that they can actually raise privacy concerns to a CEO level concern instead of just something that the tech folks at the firm are looking at.
Mr. McTaggart.
I just agree with everything that's been said. You need trust and check, and the check part needs to have some stick to it as well.
Let me start with you again, Mr. McTaggart, on tech and telecom are sort of in a fight about who's supposed to comply with what privacy laws. And, there are no angels. God bless them all. We have working relationships with all of them, but there are no angels. And they want rules for the other, but not for themselves. And I wonder if you wouldn't mind just spending a minute or half a minute talking about the need for whatever we do as federal law to apply across platforms and business models.
Yeah, I just think any federal legislation needs to be strong, effective, and meaningful. As has been said before, you do need a robust enforcement mechanism. I can see why the companies want this, but I think what you said is exactly right. My experience, just even in the cleanup bill in August in California, was that there were a couple of tiny little words inserted that they tried to say this is just clarification, and then the reality is if we'd let those stay, that would have totally gutted the law. And they have the smartest lawyers in the world pushing hard. So that's what's going to happen. They're going to try to deal with California first, and if they don't get it, they'll try to come here.
Thank you.
Thank you, Senator Schatz. Senator Cantwell.
Thank you, Mr. Chairman, and thank you for holding this hearing and the witnesses, and I thank Senator Schatz for his questioning because it's along the lines of what I wanted to ask about. I used to say that we were just at the tip of the iceberg of the information age. Now I'm pretty sure we've looked under the waterline and seen this massive amount of data, information, application, integration, opportunity, but now I'm pretty sure we have a pretty good sense of how big the information age really is and the implications for us. Every day we see threats of cybersecurity, not just companies being hacked, but state actors causing great concern as they look at our power plants or electricity grid. So all of this is incredibly important. And I feel like the panel is presenting two different, opportunities here, either the GDPR model or we get the FTC, as you just all advocated, to have fines and regulatory authority in a broader fashion. So I appreciate that. I would ask about the fact that we didn't really, my colleague didn't really clarify, but if you could clarify, because we talk about the misuse of data on the OPM or Equifax issue, which to me is always amazing again, because Equifax, there was a patch. There was an Apache patch that just had to get done and somebody didn't do it. So this whole issue of hygiene is something that we work really hard on in the state of Washington, trying to clarify with our National Guard and everybody else. These are the basics of, hygiene that you need to be doing every day to protect your business, your home, devices, what have you. But misuse of data is also a concern. So not just the theft of somebody leaving you vulnerable, but the actual misuse of data. So should that be covered under those FTC fines or regulations? Could you comment on that?
In our proposals that we're working on with a number of your staff, and I thank you very much for that, we are particularly concerned about secondary uses or extraneous uses of the data when collected for one purpose but then used by the same company for another purpose, particularly if that data is highly sensitive, biometric, or children's or health indicators. We're also obviously concerned about third-party transfers and uses that were unexpected to the individual consumer. And I think you're so right to make the point that this is a larger ecosystem. It is not only about technology companies or telecom companies. Data is flowing on and offline through traditional companies and tech companies. Our phrase really is everybody in the pool, that this is a law that's about the individual and their rights in their data, no matter where it flows in the ecosystem.
Thank you.
So I just want to clarify that I think that both approaches are ultimately necessary. Both baseline privacy that comes from a place of principles, as well as increased authority for an expert agency in the form of rulemaking, civil penalty authority, and greater resources. But then I also think that we may need heightened protections as it relates to things. So on your question of uses that might be prohibited, I think, as I mentioned in my testimony earlier, information about consumers should not be used to discriminate against them. Right? Information about consumers should not be used to deny access to or just awareness of opportunities that relate to things like education, finance, and healthcare. Right now, that is going on, and I think that we need more than just privacy to deal with that. We need regulations that prevent use of information for those purposes, or at the very least that create greater protections around it, greater transparency about how information may be used for those purposes, and accountability for consumers. And we may need heightened standards as well in other areas, as my colleagues have mentioned, heightened standards around children's information, heightened standards around biometric information, et cetera.
And what about election meddling? I'm reading these stories now about this Israeli company that was promoting these concepts of here's what you could do. What do we do about that? Disclosure? What do you do?
I think that's obviously an extremely difficult problem that I don't think there's any easy solution to. I think in the near term, we certainly do need greater information about how data is being used to target not only advertisements for specific political candidates, but information that relates to issues of central importance in elections that may sway voters' decisions. We need greater transparency so that researchers can get in there and study it and find out the extent to which this information manipulation is changing voters' behavior, because it surely is.
Mr. McTaggart, do you have any comments on that?
I would just say I think there's nothing more important for this committee to focus on. Never before, someone talked about oil before. Standard Oil was powerful. They didn't know everything about you. We've never before had a situation where companies know everything about you intimately and can communicate to you at essentially zero cost. This is a new technology. It's a new thing, and there's nothing more important for this committee to consider.
Well, I thank you, and I know I'm a little bit over, Mr. Chairman, but I think one of the witnesses said it best. This committee is here to protect these consumer rights. So often this committee is engaged in the arbitration between behemoths in a tech sector or maritime or aviation, whatever it is. But here we have to remember our duty and responsibility to protect consumers on their privacy rights that I believe are very strong in our Constitution. Thank you.
Thank you, Senator Cantwell. Senator Duckworth.
Thank you, Chairman Thune and Ranking Member Nelson, for holding this important meeting. I'd also like to thank today's witnesses for an honest and frank discussion. The reality is that the federal government has fallen behind the curve in protecting digital security rights. And as an online shopper, in fact, as a mom of two girls under the age of 4, if it doesn't come from Amazon, then I'm not getting it. It's just the way it is. I recall receiving various notices and disclosures from technology companies highlighting changes to their policies and procedures in order to comply with the European General Data Protection Regulation, as did most online consumers. As a U.S. Senator, I was really struck by how EU's actions shined a spotlight on our Congress's failure to modernize federal privacy laws and regulations. I would also notice that despite the alleged stifling impact of the EU's comprehensive regulation by some, the sky has not fallen in Silicon Valley, and technology giants continue to grow and thrive. Ms. O'Connor, federal agencies within the U.S. Department of Commerce, specifically the National Institute of Standards and Technology and the National Telecommunications and Information Administration, have begun to develop a privacy framework to help address risk and build trust between industries and individuals. At a recent Brookings Institution forum, the director of the National Institute of Standards and Technology highlighted the industry's preference for a light touch regulatory approach and suggested that it is too soon to determine the impacts of GDPR and that the California law will be on privacy outcomes. At the same time, he also questions each law's sustainability. So he said it was too soon for us to look at how effective the GDPR is or at or how California will be on policy outcomes. So my question is, I'm not asking you to get into the mind of the NIST director, but from a practical standpoint, how does one gauge the impacts of GDPR and CCPA on products and services that require user data?
Thank you so much, Senator. And I was not there for that comment, but I would say that we are 25 years on from the dawn of the commercial internet. I think we have tried self-regulation. I think companies have flourished. I do not think it is too soon to consider this question. I think it's high time, if not past time, to consider how we protect your and my children and all internet consumers in the future generation. I don't think we can wait another 25 years to regulate. Do we think that there are challenges with the GDPR approach? We think the values both in the GDPR and in the CCPA are sound, and they reflect the primacy of the individual and their interest in their data. Do we think perhaps there's a lot of notice and maybe not strong enough boundaries about what kind of data should be in or out of bounds for companies to use? Certainly these are questions for this body to consider, but I think the values are sound, and I think we are, if anything, late to the party.
Well, so is it too soon, though, for us to be able to measure the improvements on privacy outcomes from GDPR? I sort of feel like people are saying it's too much, it's not happening, there's not enough good coming out of it, but I feel like it's just been implemented. Is that an accurate assessment?
I think that's a fair comment to say. I misunderstood perhaps and thought you meant it was too soon to regulate. It is probably too soon to judge what the eventual outcome and challenges are to companies doing business inside or outside Europe. But the fundamental values of respect and dignity to the individual, of allowing them the transparency, allowing them the data portability, particularly, which Laura and others have mentioned, allowing more power in the hands of the individual vis-a-vis a large institution actually rebalances the power equation. And I think that favors, in fact, small and startup businesses over incumbents, or at least levels the playing field a little bit more. So a clear, simple standard for U.S. companies to know what they are allowed to do with our regular personal data or sensitive data is a good move.
So then how would one gauge the sustainability of any type of privacy framework that we can come up with?
Well, Europe has had a general a data protection directive for 20-something years. In the United States, we have had a sectoral approach, and we can certainly look at what kind of successes or failures or challenges we've had in our health privacy laws, in our financial institutions laws, in our children's privacy laws. I think we can build upon those without weakening those standards and take the best from each of our frameworks. But I think most importantly for companies of all sizes, clear direction about what they are allowed to do with and to consumer data that they collect in the ordinary course of business is necessary.
Thank you. I yield back, Mr. Chairman.
Thank you, Senator Duckworth. Senator Klobuchar.
Thank you very much, Mr. Chairman. Thank you to all of you. I had another hearing in between here. I want to also thank Senator Markey. And I think you all, probably everything's been said, but I haven't said it yet. That's the old Senate saying. So we've had a very, I'd say, a watershed year that we've never seen before when it comes to consumer privacy, where people are finally coming to grips with this. Just last week, we saw additional data breaches at Google and Facebook that exposed the personal information of millions of customers. Senator Kennedy and I have our Social Media Privacy Protection and Consumer Rights Act, which I think just has some baseline protections. Thank you for nodding your head, Ms. O'Connor. And it is a bipartisan bill. A few things. Ms. O'Connor, do you believe there's a need for this kind of legislation? And what consequences do we face if we don't have some kind of privacy law in place?
Thank you so much, Senator Klobuchar, for that question, and thank you for your leadership on this issue. I was nodding because we do obviously applaud and support the principles ensconced in your legislation, and I would simply like to see legislation that affects and impacts all commercial entities across the United States, regardless of what sector they self-describe themselves to be in. When I am doing business online or off, I don't necessarily know that the company I'm doing business with is governed by the Telecom Act or HIPAA or COPPA or whatever the patchwork of laws that we have at the federal level is. I simply know that I want to get the good or service in front of me. I want to know that my data is not going to be used in ways that far exceed my expectation about what is the transaction in front of me, and I want to know that the data is secure. So yes, I think it's high time.
Dr. Jelinek, can you explain why the GDPR includes this 72-hour notification window? We have that as well in our bill, but could you explain it?
As I mentioned before, I wasn't negotiating the GDPR, but as far as I see, the 72 hours of notification of a data breach are not a problem for the companies, because if the data breach occurs, they just know it and they have to record it to the data protection authorities. And the first notice doesn't have to comprise everything because they have to investigate too. And until now, the 72 hours were never the problem. The problem is if someone wants to hide that there was a data breach, and then you can have 1 week, 2 weeks, or 3 weeks. They don't want to. If you don't want, they don't want to tell you. That's the problem, not the 72 hours.
Mm-hmm. Can you explain how Europe has approached the concept of withdrawing consent? Someone consents to have their information used, they change their mind. How important do you believe that this protection is to be able to give them that right? This
protection is not a new one. This was already a right under the Data Protection Directive, but consent is only one point which is possible to give, because you can rely on law if you are processing data, or on legitimate interest. And so consent is not always the point, but when you have the free will and you have the consent, then you have then you can withdraw the consent. And until now, the withdrawal of the consent have never been a problem during the last 20 years of the Data Protection Directive, and I think there won't be any problem regarding the GDPR regarding this point.
Okay, Ms. Moy, the bill that I with Senator Kennedy preserves the rights of state attorney generals to take action against companies when privacy violations occur. What role do you see those attorney generals, what they can play in policing online marketplace? And how does their authority complement the FTC?
Great, thank you for that. So state attorneys general, they do a number of very important things, but a couple that I'd like to highlight are: one, state attorneys general can take action when they're dealing with small cases that may not rise to the size or number of consumers affected that would trigger enforcement action on the part of a federal agency. The Federal Trade Commission does a lot of work on data security right now, but it only has a staff, I think, of around 1,100 people, and there are thousands of breaches that take place at a small level that may only affect hundreds of consumers at the state level. State attorneys general are doing really, really good work there. State attorneys general are also doing great work consulting with businesses and stakeholders in their communities to try to provide the necessary guidance that that companies need to understand what their obligations are, and that consumers need to understand what their protections are.
Okay, thank you. Well, I had a question for you, Mr. McTaggart, but there's a glass ceiling and you didn't make it through. So I will give you one in writing. Thank you.
Thank you, Senator Klobuchar. We definitely want to protect the privacy of Green Bay Packer fans living in the state of Minnesota.
Excuse me, did you see that the Vikings beat the Super Bowl champions this weekend? If you want to give Viking grief, you didn't pick the right week to do it. Thank you.
So let me just direct this to Ms. Moy and Ms. O'Connor. Just sort of wrap up. I think we've got to vote on, actually, so we're going to have to head over the floor here momentarily. But are there provisions of the GDPR and the CCPA that you think we ought to include as we look at and contemplate federal legislation and or specific provisions in either law that we ought to avoid or that need to be improved?
Sure. So, I think a few things that I would highlight about the GDPR. So, one, as I've mentioned before, the substantial fining authority, such that fines really can rise to a level that provides the right incentives for companies under the GDPR, and we desperately need that here in the U.S. Another thing that I would highlight is this idea that consent, when it is given on the part of a consumer, must be freely given, is something that is really important for us to incorporate into any principles that we have here in the U.S. Because it recognizes that where a service is essential and unavoidable for a consumer, then consent might not be freely given. It also recognizes that where consumers are charged a penalty for failing to provide their consent, then if that's a penalty that is coercive, or if you're dealing with a consumer who simply can't afford to pay that, then that might make consent also not be freely given. I think that that's something that's really important to consider. Of course, the data minimization and purpose limitation principle is great as well. The GDPR really does have a lot going for it.
Both of the laws ensconce some basic data protection principles that there seem to be general agreement. I'm surprised to see companies agreeing to things that 10 years ago we would not have seen such widespread assent to notice and choice and access and deletion and correction, and most importantly, portability, which allows the individual consumer control over their data. So the core values, I think, are largely consonant. Where I think we don't see enough is in guidelines and bright line rules in the GDPR about what should not be done and what kind of data should not be collected and used. And while on CCPA there are drafting and definitional questions, and we have an annotated version of the bill on our website at cdt.org, we think that the values are sound and the enforcement mechanisms are sound. We want to see coverage for all entities, large and small, because we think there could be tremendous damage even from small companies' use of large amounts of data. And we want to see clear guidance and delineation of secondary uses and third-party uses. But overall, we're supportive, and we don't want to see those protections weakened.
So last week, or 2 weeks ago, when we heard from the leading global technology firms, the testimony was that some companies are having to devote huge resources in order to comply with GDPR. Could you just kind of describe for us what the average GDPR compliance costs are for companies? Ms. Jelinek.
Mr. Enright was quoted that Google had to spend hundreds of manpower years to be compliant with the GDPR. If you take into account that Google has, according to the latest figures, 85,085 people, and you think 200, and you take 200 years, then one employee of Google has not spent more than 3.5 hours for compliance with the GDPR. That's the first. The second is, I think if these tech companies would have been compliant before with the directive, with the data protection directive, they wouldn't have had to invest so much money because, as I said before, GDPR is no revolution, but just an evolution. And so I think, and most of the tech companies really tried to be compliant and develop robust systems regarding their customers. But as we hear every week, there are data breaches and other things that occur, and I think this stresses very good and very well how important the GDPR is and the provisions for the consumers, for the individuals, because the GDPR gives back the individuals their control over their personal data, because they have the right to free consent, the right of access, the right of deletion, and some other rights which are core principles of the GDPR. And as already said before, I think Americans don't deserve less protection than the Europeans. Thank you.
Great. Well, listen, we'll probably have other questions which we'll submit for the record, and we would ask that if you could get those responses back as quickly as possible to members of the committee, and we'll keep the hearing record open for a couple of weeks in order to allow for that. But we greatly appreciate your time, your input. Yeah.
Can I just compliment you on the uniformly excellent testimony from each one of the witnesses? It was really an extremely high-quality panel. I want to congratulate you on that and on to the witnesses yourselves. Thank you.
Thank you, Senator Markey. And yeah, we got lots of good input and responses to questions, which will help us as we make decisions going forward. So thank you all very much, and we will keep the record open, as I said, for a couple of weeks. But with that, this hearing is adjourned. Thanks.
Thank you.